Okay, next up, the Supreme Court, by Justice Alito, issued a stay. The stay heard round the Twitterverse. Upon consideration of the application of counsel for the applicants, it is ordered that the April 7th, 2023 order of the United States District Court for the Northern District of Texas is hereby administratively stayed until Wednesday, April 19th at midnight. It is further ordered that any response to the application be filed on or before Tuesday, April 18th by 12 p.m. David, that sounds really boring. Why? Ever so why would this have made so much news?
Well, because what is it staying, Sarah? We haven't said that yet. Yeah.
Oh, yeah. It's staying that abortion pill ruling from Judge Kaczmarek in that Texas case. Remember, we had the dueling injunctions of sort. And by the way, they did become fully dueled because the district judge in Washington clarified her injunction to say it is in direct conflict with the Texas one and stuck her tongue out and went, nah, judicially speaking. Okay, so in the meantime, though, remember Judge Kaczmarek had stayed his ruling for 7 days to allow for appellate review. The Fifth Circuit did appellate review it, issued a 42-page opinion, which is quick in short order. I think that there was some misunderstanding in some of the news stories that I read that said that it was 2-1. That's not quite true. All three judges were going to stay part of it. And the judge who dissented in part wasn't on the merits. She was just saying there should be an administrative stay rather than a stay on the merits, which is what the other two had done. I know that's a little bit in the weeds, but it annoys me to see things that are slightly wrong. Okay, so the Fifth Circuit granted in part and denied in part. In short, what they said was, look, that reopening idea that you had where you can now reach back 23 years to the 2000 approval, nah, dog. That just got hard nah dogged. But everything from 2016 on was going to live in that opinion. They found that the doctors and the group of doctors, the organization, both had standing, which was fascinating. And something that's going to come up. And then, of course, the Supreme Court, Justice Alito, was like, administrative stay while we sort this all out. And remember, an administrative stay, they're basically saying we don't have time to even look at the merits. This has nothing. It's like we didn't read anything at all. We're just keeping status quo in place while we look at it. It doesn't tell you anything about how justices are going to vote on this whatsoever, except that they think it's important enough to review. David, did you have any reactions to that Fifth Circuit opinion? Do you think the Supreme Court's going to agree, disagree? Where do you think this is all going?
Yeah, so I had a couple of reactions on the Fifth Circuit opinion. And the main one was, it was unsurprising that the reach back theory did not survive. That one was the biggest stretch of the district court's legal theories. I'm mostly interested, actually, and very interested in the ultimate standing ruling. That's the one that I think is going to be the most interesting legal consequence versus sort of the real world consequence of how available is this abortion pill. But the most interesting legal consequence, because how many times have we talked about standing, Sarah? We are constantly talking about standing and whether or not the concept of standing is being really, truly expanded to such a degree that it's just going to be ever easier to get in court to challenge government actions. And this is exactly the kind of case where you might see that further extension of standing. We have the student loan case, for example, hovering out there, where you might see some movement on the standing doctrine. So that's where, as a legal consequence, I think of this case, the most enduring element of this case. Now, of course, the real world consequence, because how many people are walking around the streets of the United States thinking about standing?
Me.
You're thinking about it. All of our legions of listeners, which you are legions, but a scattered legion. You're probably not going to bump into each other and too often on the sidewalk. Aside from our legions of listeners, the availability of the abortion pill itself is the core fundamental outcome here, that for which standing may be ultimately be the core determinant. So all of the interpretation of the Alito stay that I've seen some online saying this means the Supreme Court is leaning against the plaintiffs in the case. No, it's administrative, as you said. It means nothing other than a pause button. That's it.
So Jonathan Adler wrote up his take on the standing thing at Reason, the Reason blog. I thought I'd just read a little piece of it because I think it's interesting here to understand what their arguments are and why he thinks they're quite weak. I'm not sure that I think they're as weak as he thinks they're weak. But before I get into that even, this, David, is something that's coming up more frequently at the court. And I think standing is the best example I can give of it. But culturally and politically, it's coming up every single day and all the time. And this is to fight the other side. Do you say that the thing they're doing is wrong and we're not going to do it? Or do you say the thing they're doing is wrong and so we're going to do it too to teach them a lesson? And on the standing thing, especially because the number one place that I think conservatives would say that standing has been most abused is the abortion context.
Yes, true.
Also the environmental context, but abortion probably would be number one. And this idea that either the justices on the court can say, nope, you do not have standing. Otherwise, standing is becoming less and less even meaningful of a test for these cases. Or do you say, well, you know what? You found standing for all of these doctors who wanted to perform abortions when they were suing in the pre-Dobbs era. So here we are. What's good for the goose is good for the gander. Now we have standing for these doctors as well who don't want to perform abortions. It's not as simple as that, but it will feel that way. So here's Adler's take. And remember, for standing, just for those who are playing at home, Article 3 standing requires, among other things, that plaintiffs have suffered an injury in fact that is both concrete and particularized, and actual and imminent. Speculative injuries or those based on mere probability of future harm are insufficient. And here's him writing, here the plaintiffs argue that some of their member doctors suffer an injury because they have to provide medical care to women who suffer complications from mifepristone. Assuming that this constitutes an injury, a contestable assumption, the plaintiffs have a problem of identifying that this injury is actually going to happen to them as a result of the government's actions. The Fifth Circuit panel seeks to overcome this hurdle by arguing that plaintiffs are statistically certain to suffer their alleged injury of having to provide emergency room care to women suffering complications. But to make this argument, the panel had to sidestep existing doctrine and play a bit of sleight of hand with the relevant allegations and claims. For starters, the claim that an organization can claim standing because there is a strong statistical probability that some of its members will suffer an injury from a government action has been expressly considered and rejected by the Supreme Court, most notably in Summers versus Earth Island Institute in 2009. Goes on to talk about Justice Scalia saying that, and this was the case, David, about people visiting the parks. Justice Scalia rejecting says, some unidentified members have planned to visit some unidentified small parcels affected by the Forest Service procedures and will suffer unidentified concrete harm as a result. Not enough. Scalia explained that would, quote, make a mockery of our prior cases, which have required plaintiff organizations to make specific allegations establishing that at least one identified member had suffered or would suffer harm. The Fifth Circuit does not even mention this case. The statistical certainty, by the way, is that 2 to 7% of cases of women taking mifepristone will involve potential complications from the drug not fully working. Because 5 million women have taken the drug since 2000, that's between 100,000 to 350,000 cases in which women have needed additional treatment. But note, that's for a 20-plus year period. On an annual basis, that's 5,000 to 17,000. And here's Adler, even making the demonstrably false assumption that all of these cases require a visit to one of the thousands of emergency rooms in the United States, it is far from a statistical certainty that one of the plaintiff doctors will handle one of these cases, as these cases represent a tiny fraction of the over 130 million emergency room department visits each year. Fair enough. There's a little bit there. I don't think it's as strong as he made it, in part because the Fifth Circuit does go through multiple of these specific doctors who have handled specific injuries coming into their emergency rooms related to complications from women taking this drug. But I actually agree with him that I'm not sure that's an injury. A doctor having to take time away from other patients to treat this patient because of a complication from a drug that the FDA approved? Woo, that's not concrete to me at all.
Yeah. Yeah. It would seem to me that you would have to show some degree of severity of the problem that is requiring an additional expenditure of resources, perhaps costing them money in some concrete way. But the idea that
the doctors are salaried and work for a number of hours.
Yeah, that's the issue. Is the question is, by treating the patient as a doctor, what is the harm to the doctor? That's the key issue to me in the standing analysis. I'm pretty darn convinced, and looking at the Fifth Circuit opinion, that it's probable to certain that these doctors will end up treating individuals who've taken the pill and have suffered complications from the pill. Again, probable, perhaps certain, but at least probable. But the question is, how does that hurt the doctor? That's the key question to me, Sarah. And you hit the nail on the head. Now, again, let's go back to how we framed this from the beginning. If you're extending and stretching standing doctrine to not really mean concrete particularized injury, but concrete particularized impact, or some sort of way in which you are part of the process or part of the treatment, then that changes the analysis. But as of now, when you think of standing, you think of injury, not just impact, not just that you're involved, but that you're injured. And that's where I think this case is. This is where the plaintiffs are going to have their biggest challenge.
So we'll see. This will all be moving relatively quickly. We expect something from the Supreme Court in advance of that administrative stay lapsing next week.